You ready to reconvene? We're going to reconvene our meeting following an executive session in which we discussed personnel matters. We discussed matters for the police personnel and matters for the township manager. And I'd like to talk a little bit more about the Act 74 and Act 74 compliance. Paul, you want to lead that discussion?
Yeah, I would like to make a motion that we enter into and sign an amendment to Mr. Williams' employment agreement that makes his employment agreement compliant with Act 74. Act 74 is a recently passed ordinance that deals with employment agreements for township managers of second-class townships. And it does not change Mr. Williams' employment agreement in any way. It just sets a term on his employment agreement so that his employment agreement is compliant with that provision in Act 74. Mr. Williams continues to remain an at-will employee. That is, he can be discharged at any time. So entering into this amendment does not guarantee him any future employment. He was always an at-will employee. But what it does do is corrects a fault that's in his current employment agreement, because his current employment agreement is not Act 74 compliant with regard to its term. His current employment agreement has no term. It's perpetual. It's unending. So I made a motion to that effect.
Okay. Joan, do you want to hear the rest of my explanation?
Well, I'm sorry, what are you explaining?
Okay. What I tried to point out is from the Act 74 standards that went into effect in September. The text changes in Paul Williams' employment contract, which you're familiar with.
Yes.
Amending to comply with Act 74 does not extend any benefits that are not already defined in his employment contract. The status of at-will remains. That's a condition of Act 74. That doesn't change. So if the board in 2012 does not retain his services, that doesn't change. Benefits extended to him doesn't change. I see no harm in doing this.
Excuse me.
That's right.
I see real harm. Number one, we were called in here and blindsided by this. First time I've ever heard of this. On tonight's bills, there is a bill for the lawyer, which Mr. Williams has had time to sit down and conference with a lawyer over this. All we have tonight are two non-lawyers telling us this is fine. And this lawyer, Mr. Williams, is the same one who wrote the contract. My request has been that they give me time to consult a different attorney to see the impact on Marlborough Township. Don't tell me there's not one, because whenever somebody wants something, there's bound to be something else that pops up. I do not like it. It was not given to us. Well, Ryan had it. It wasn't given to me prior. to this meeting, and Marlborough now, well, they'll all be enjoying whatever they're doing, but I'm not doing it.
I'd like to respond. What I had, and you should have all been mailed copies of this in September, the changes to the second-class township code.
We got that in the mail, correct?
That's what we're looking at. That's what this is.
We're looking at a change of plan for an employee. You wouldn't do the manual without a solicitor's advice.
This has a solicitor's advice. It was prepared by the solicitor.
I know the same solicitor that provided the original.
I've read the act.
I got it.
Okay. If you would have stayed and finished comparing this.
I'm not interested in comparing that with the act. What I want is a legal opinion about the impact on Marlborough
Let's take a couple
Township.
quick questions, and we're going to move on. Claire.
I hope we're not quick. Who decided on the executive meeting, and who decided what was on the agenda?
I called for an executive meeting, and we all discussed this simultaneously.
You all discussed it before tonight.
No.
You didn't know anything about it, Carl, before tonight?
I did not have access to any of this information.
Did you ask Brian to do it?
No.
Okay. Let me tell you what the law says. Now, you missed something. The term of such an agreement cannot bind future governing bodies because it may not extend beyond the date of the organization meeting of the governing body following the next municipal election after the effective date of the agreement.
And that's exactly what we read, Claire. That's exactly from Act 74.
Exactly. The election occurred, right?
Right.
Now you're going to try to sneak the new agreement in after the election and extend it for 2 years? That's not what the law says. I'm sorry, we have a new board coming in January.
And that new board will have to make a decision.
But why are you complicating it? Why are you complicating it?
Transparent.
So your agreement will be good for what? 10 days? Then we have to go through all the whole legal unwinding. This is really...
You gonna let me talk to?
No.
Not, then I'm gonna go for a vote. I'm here to talk too. I thought I'm running the show here.
Yeah, well, go ahead. Okay. Yes, answer it. Tell me how the next board...
No comment. Next question. In the back, Brian.
I get the drift here that the intention of the future board seems to be to replace Mr. Williams.
That will be a decision the 2012 board will have to make in January.
So you are not making that decision, and Mr. Williams will remain an at-will employee, and the board subsequent to your tenure can make that decision.
The position of manager, as defined in Act 74, as currently defined in Mr. Williams' current contract, is at will.
Okay,
That's
the point that
yes, that's defined in Act 74.
So there's no contract article.
It's listed on this amendment. If we choose to take action on it, it reinforces the fact that it's at will. And it puts it on the 2-year cycle defined by Act 74.
Brian, Mr. Williams' current employment agreement has a fault in it.
Right.
The fault in it is that it does not have a term.
Right. I gathered that from your description.
Act 74, which was passed July of 2011, says that all employment agreements have to have a term. We're just correcting that fault so that that technical blemish does not exist on his employment agreement.
The employment agreement has no expiration date.
Right.
And this gives it one.
It's time to...
Regardless of what the board will choose to do in January. Charlie.
This Act 74 establishes a term of 2 years after the execution of the employment agreement.
Correct.
So he does have a termination date. His termination date is 2 years after the effective. You want to essentially renew his contract effective tonight and then establish a 2-year term running from this point. Is that what I'm hearing?
The term is for the agreement, not for his employment.
Correct.
What's the difference? The agreement is his employment.
No,
listen.
He's an at-will.
I would like to read from the minutes of the November 22nd meeting. This is a motion which was approved. You are now violating the motion, which I think is something you have to talk about. This is the motion made by Carl that and I'll just read number 3. We agreed to review his employment agreement every 2 years, starting 1/1/2012, to coincide with the election or re-election of a supervisor. Now, I think we did elect a supervisor. Your motion says we will do the review in conjunction with the new supervisor. Now, are you saying that this motion, you're repealing this motion? This motion has the weight of law. It's recorded in the minutes.
It doesn't say that we couldn't do one sooner than that.
Oh, come on. You know what? This is serious games. There's gamesmanship here. You're blindsiding one of your fellow supervisors. That's monkey business. There's no need to do anything tonight. There will be no harm in doing it on the 3rd. And quite frankly, if you do this tonight, we have a full record of it. I'm not going to go by the minutes. We'll go by the full record. I will definitely have a call into the Attorney General tomorrow and the District Attorney, because you are playing with the law. It clearly states that the new board shall deal with the contract. If you wanted to correct it, why didn't you do it in October? Why did you wait to the very last meeting of the year? I know why, but I'm not going to say why. Why didn't we do this as soon as you knew it had to be done? Why did you wait until the last hour and then come in and blindside the fellow supervisor and pass something which you know has to be undone, and it's going to cause a lot of trouble to undo it? Brian, believe me, you're going down a very bad path. Carl will be gone, but he's still going to be responsible. Can't walk away with it. And I think I'm not making any threats. I'm telling you what needs to be done. The law is clear. The code is clear. The code tells you the agreement terminating no later than 2 years at the effective date of the agreement on the date of the Board of the Supervisors organizational meeting. Clear. This is the code. This is the law. The key to the whole thing is the organizational meeting. If you wanted to do this, then you could have done it before this. This has a lot of political overtones. I'm not going to talk about them, but you're making things very difficult for yourself in the future and for the next board by doing this. And I think you're really on very, very thin ice if you're going to vote to do this. There is absolutely no deadline to do it. Thank you.
Dan.
I know Carl's political motives are. I know it's a waste of time to discuss this with him. But Brian, I don't understand why you try to cloud this up. It's very clear what's going on here. It's very easy to see what's going on. Why would you do something like this?
That's not the case.
This is a lot bigger than you guys think. I don't think you thought this out clearly, because this is a lot bigger than you even anticipate what's going to happen. And it's going to be a negative effect on you and whoever tries to pass this.
Is the agreement written?
Brian, can I make a comment?
Sure. Everyone else is.
In January of 2006, when the former township manager was notified that her employment would not be continued, it became a very difficult severance for the township because the former township manager did not have an employment agreement. And the former township manager thought she was entitled to many, many things that the board did not agree with. And the whole reason of entering into an employment agreement was to make it clear at the beginning of the new township manager's employment what his end of employment would constitute. And that's why the employment agreement was put into place. It was to protect the township. And this amendment that we're putting forth is to protect the township. It protects the township by defining by continuing Mr. Williams' employment agreement and the severance that is described in that. And it protects the township from any claims Mr. Williams may have in excess of what is stated in that document.
John?
Carl, you said we knew about this in July? Is that when?
The state law was passed in July.
And why are we waiting until now? My question is, why are we waiting until now to handle this when we should have handled it beforehand? It should have been addressed a while ago instead of waiting until the last meeting. I mean, I don't see. Now let me ask you another question. If you go into this and approve this, does that mean he's guaranteed things he wasn't guaranteed before?
No, it doesn't.
What's in the new agreement?
The new agreement is the old agreement. The only thing that changes is the employment agreement now has an ending.
You mean you would offer that same agreement after all the problems that it's caused? Like that agreement, you've broken it already.
We have an agreement in effect. That hasn't changed.
Oh yeah, no, yes it has.
It has not.
The way you pay them has changed.
This is the same
Benefits have
that
changed.
you all filed right to know requests for. It's the 2006.
It's not true. It's not the same agreement. You changed the agreement. The motion that Carl made changed the agreement. Right here. Okay.
Hold on, Joe.
Okay.
More time.
Delinking the salary adjustment from the police, discussed revising the car allowance. Okay, thank you. Sorry.
You know what I said before is true. I was blindsided. I did not hear this ahead of time. I would like to have an independent legal review to see that the township is not being, pardon the expression, I don't think I can make that in public. But what we need to be mindful of is that we come out of this without any additional burdens. That being said, you have a motion on the floor and a second, and there is nothing you can do about it at this point. So I would suggest that we all take a deep breath, think pleasant thoughts, go home and get your Christmas presents done. They have 2 votes. And I'm perfectly willing to go home. You can't do anything about it, and neither can I.
I want to hear everyone's comments. I'm willing to, again, discuss this with you in executive session if you're willing to continue.
Please, Brian, this was set up ahead of time. There is nothing that can be done in executive session. I want another legal opinion. We spent several $100 getting him one. Doesn't a dissenting member of the board deserve to get an opposing opinion? So there will be 2 sides to this.
Absolutely.
That's all.
Let's do the rest of our comments. I think, Brian, you came up mine. I don't know who was first.
Sorry.
Couldn't we make his expiration date the date of the new board? Or if you guys say you haven't had any, you said you didn't discuss this before, No one's told Mr. Williams he's leaving. Why are we talking about it if you haven't discussed it before this?
That's up to the board in 2012.
I mean, why are we discussing it tonight if you didn't discuss it before this meeting? Both of you said.
Right.
If you didn't, nobody's told him he's leaving. Why are we discussing it all at once and wanting to pass some kind of expiration date?
Because I think this board owes it to our employees to finish what hasn't been ended.
Can't the expiration date be when the new board takes over and let them decide?
They can. It's at will. So the new board can do anything they want in January.
So you're states they can do whatever they want, but why are you complicating it by passing something when obviously one person in the new board has great problems with doing that until it's reviewed? So you have a favored majority. It's a lame duck session. It's about the lamest of the lame duck because you can't go any further away. And it just seems to cause a crisis. And all of a sudden, we've got to do this. You remind me of the people in Washington. They drive me nuts.
Well, the year isn't over yet, Claire. So let's the rest of the comments, and we're going to continue to talk.
I'm done.
Don't you think we should wait till the first of the year? I mean, I'm not an expert at this, but I think you should have more input on, and more input on what the people think should be done, other than just 3 people making that decision.
In January, if the 2012 board releases Mr. Williams' employment and chooses to hire a manager and utilizes this contract form, it's on the 2-year cycle. So,
But that's got to have a financial impact or something, or you wouldn't be screaming and yelling to do this.
He's going to be here.
I know what the rest of it is.
He's going to be here anyway until the new board takes over. So why do we have to have a vote on something tonight?
You can't wait till the first of the year. I mean, why all of a sudden we have to make this immediate decision?
I wasn't thinking about it as an immediate decision.
What's the difference? Well, it seems like you just want to make it tonight. But if you don't make it tonight, what's the difference in what happens after the first of the year?
Agenda, I was trying to resolve all the employment items that have gotten pushed down the line.
Well, this was never pushed anywhere.
There's a lot of issues that should have been resolved all through the 3 years that I've been coming here. And I don't see how it's going forward with none of them. Why all of a sudden we have to hurry up and go forward?
This was passed in July and became effective in September, so we've only had since September to address it.
Well, then why didn't we address it back in September or start addressing it so that everybody would know about it?
Because you didn't want public input on it.
Brian, you're trying to desperately.
Okay, I guess I have 3 questions. Am I correct that the computer situation with the servers took 1.5 years to get resolved?
About.
Thank you. Does the motion that's on the floor bring Mr. Williams' employment contract into compliance with this newly enacted Act 74 in terms of creating a term?
In my opinion, yes.
Okay.
Does it?
Wait a second. I have the floor.
Easy.
The third question is, does this change Mr. Williams' employment contract in any fashion?
No.
Why are we voting on it then? Why do we have to vote now? Why not let the new board decide?
Act 74.
It corrects a defect in his current employment agreement, and tonight is the last opportunity
Then we
I
can-
have to cast a vote.
We can put a termination date of the new board. Let them decide it.
Your motion said the new board.
I would prefer to decide it.
I bet you would.
Your motion, you're playing against your motion.
Thank you, Claire.
Yeah, well, you are.
Tim said
Thank you,
it's
Carl.
How many years did Paul Williams write his own contract? And why is this so original all of a sudden at the last 9 o'clock hour? I know why Carl's doing it. I don't understand why you're doing it. It has a lot of implications on it.
I didn't hear you first. When did you write the contract?
Yeah, how many years ago?
6 years.
This
So he wrote his contract 6 years ago.
This contract started in 2006.
And now, at 9 o'clock hour, when Carl's on his way out the door, it's now all of a sudden urgent to do and create something new and without logic to do.
It's not creating It's not creating anything.
Yes, it is. You're changing something.
You wouldn't fight so hard
Something new.
Carl, you can't stand losing, can you? You might as well get over it, pal, you're done.
Brian,
Okay?
This is an election.
Brian,
No, but it's becomes political.
It's the after effect of it.
Brian, I don't know if you realize this or not, but when you have the new board, you are creating an awful lot of animosity if you vote for this with your new board. Because obviously, I don't know, I know Jen's opposed to it, and what Charlie's feeling is he's not on the board yet. You are creating a very high level of animosity for your first meeting because you are being led by a board member who is leaving, who was voted out. You are taking his position, and there is a clearly defined date in the law. The date the newly elected supervisor takes office. Now, why would someone try to make this quick correction 12 days before that happens when it was never an agenda item, it was never discussed in any meeting, and all of a sudden it comes up?
It's a personnel issue.
That doesn't matter. You can talk about personnel issues in general. You can talk about the contract in general. We have to look at this contract.
And that's why we're back here now discussing it.
Well, Brian, just think about what the meeting's going to be like in January. Because if you are creating a real issue where no issue needs to be taken, a no vote right now simply puts it down 12 days. There is no problem. It doesn't affect Mr. Williams' contract at all, as Carl has said. It's the same contract. However, maybe the new board wants to look at that whole contract. You don't need to put an extension. You can modify that. And the time to modify it is before you extend it. Now, I'm told there's no modifications, but I know there are. Because we're not paying the full hospitalization award. We're not following the police contract. We're not following the several other rules.
This does not.
It is a new contract. Thank you, Brian.
I'm perfectly no.
It's not a contract.
It's an extension of the
I'll second the motion. I made the motion.
I didn't make the second, Okay. Now, there was debate if there's a legal issue regarding a previous motion. I don't know the answer to that. If we were to reconvene at another date, is there a date this month?
There's not enough time to advertise the motion.
Wonder why it was that way.
Where we got it here, this mark was 25.
There are several liberal ones.
You can have a term resolution. The next week.
Well, then,
No,
my turn. Hate me if you want to. I will second your motion. Any additional public comments?
Shame on you.
Shame on you, right?
Thanks for your comment.
Okay, take a vote.
All in favor? Aye.
No.
Okay, and one opposed. Any additional public comments? Seeing none, motion to adjourn.
Yes.
Adjourn, we have a second? Okay,
Okay,
all in favor? Aye. We're adjourned.
Merry Christmas, everyone.
Good riddance.
Oh, I'm not going anywhere today.